Brief summary of the Mental Capacity Act 2005 and the 5 principles. The Mental Capacity Act 2005 is the legal framework that guides the assessment and decisions made on behalf of those who lack mental capacity. The Act was introduced to protect those who lack capacity and to ensure the rights of the people to make certain choices for themselves, where possible, are protected. The Act starts by setting out certain principles that must be followed. The first one is that we must assume that a person has the mental capacity to make decisions for themselves unless we can prove otherwise. This principle tells us that regardless of a person's condition or the way they present, we have to start on the basis that the person has capacity. This places the onus on the professional who has reached the opinion that an individual lacks the mental capacity to prove how they formed that opinion. Depending on the type of decision that's being made, a formal report may be required, or in some instances, simply recording in a person's notes why they were deemed to lack capacity may be enough. For decisions that have legal implications, more often than not, a formal report is required. Although the first principle states that we must assume that a person has capacity, it doesn't mean professionals should simply sit back and watch a person make poor choices if there is a reason to believe that their choices may be because of a condition affecting their mind or their brain, or lack of capacity. The second principle requires that we take all steps necessary to support a person with making a decision. For example, if the person requires the use of hearing aids or other communication devices to engage in the decision-making process, efforts must be made to ensure that they have this. Equally, if a person requires an interpreter, a signer, or assistive technology, this must be provided. Essentially, consideration must be given to what needs to be done to support the person. The third principle states that an unwise decision must not be treated as lack of capacity. To elaborate, we all make decisions that others may deem to be unwise, but as long as such decisions don't break the law and we are deemed fit to make our own choices, no one interferes with our right to make the decisions we want to make, even if others disagree with them. A common example is the choice made by some people to smoke. Some may argue that smoking is an unwise decision because of their health implications. However, people are allowed to buy cigarettes and smoke so long as they have reached the minimum age. The fourth principle requires that acts done or decisions made on behalf of those who lack capacity must be in their best interest. This means that the person making the decision must consider whether what they're doing is the most suitable course of action for the person. This includes seeking the person's views on the matter, considering any wishes they may have expressed in the past, speaking with other relevant people about the decision and considering the particular situation and the best way to address it. The fifth principle sets that consideration needs to be given to how best the objective of supporting the person can be met in a way that keeps any restrictions on a person to a minimum. For example, the fact that a person lacks capacity to make decisions about their finances as a whole should not limit them from managing an allowance which can be used for day-to-day expenditures.